Hello, everyone, and welcome to the next in our series of events of For the People. Today we're going to be looking at voting rights, and our presenter is Dr. Karen Wisely. She teaches for our Northeast campus here at Terry County College, and this is sort of a For the People / African American History Month event. Just a little bit about Dr. Wisely. She did get her PhD from the University of North Texas, Go Mean Green. And I guess that's it. So Karen, if you're ready, let's go ahead and look at voting rights.
All right. Thank you, James, for the introduction. And thank you, Dr. Chloe Northrup, for your assistance with this event. And thank you to everyone who is showing up on a pretty chilly still Friday afternoon. And when this series was initially conceived by Dr. Hathcock and myself and our colleague, Joan Johnson, we wanted it to show how the federal government could work to help people in different areas of their lives. This episode was supposed to cover minority rights in general, which turns out is an enormous topic. So I decided to narrow it a bit and to focus on voting rights because voting rights is the most fundamental of all rights. In the words of Stacey Abrams, voting rights are the most basic tenet of our democracy and the bare minimum one should expect from the government. Our presidents can send our neighbors to war, local elected officials can decide the mundane questions of trash pickup and the weightier issues of hospital closures. At every level of our lives in this republic, we choose men and women to speak for us, yes, but also to determine the direction of our daily lives. And all it takes is a teacher strike or a government shutdown to remind us how vital elections can be to the daily rhythms of life. And while we are quoting great Americans, the late John Lewis said this: "My dear friends, your vote is precious, almost sacred. It is the most powerful nonviolent tool we have to create a more perfect union." So let's look at that sacred right. The United States Constitution, as ratified in 1789, left it to the individual states to determine who is eligible to vote in elections. For the most part, state legislatures limited voting to adult, that means 21 and over, white males who owned property. There were a few exceptions. New Jersey, for example, gave voting rights to, quote, all inhabitants of full age who are worth 50 pounds, money, not weight, and have resided in New Jersey for 12 months, unquote. The other exceptions worded their laws similarly to New Jersey, and this allows for some unmarried women to vote because married women could not own property. Free African Americans were also allowed to vote under this law if they met the residency and property requirements. This little loophole lasts until 1807, when New Jersey changed their laws to, quote, tax-paying white male citizens only. Beginning with New Hampshire in 1792, states began to drop the property holding from their voting requirements. The process of installing universal white male voting concluded in 1856 when North Carolina changed their laws. The bulk of the states had done this in the mid-1820s, so this expansion of democracy is oftentimes attributed to Andrew Jackson with Jacksonian democracy, but while he benefited from the expanded pool of voters, he really didn't cause it. So universal white male voting is going to be the law of the land through the Civil War, in spite of some pretty strong agitating by the women's suffrage movement, headed by Susan B. Anthony and Elizabeth Cady Stanton. Once the Civil War was over, additional questions are going to arise about whether the freedmen should be allowed to vote. Well, that's weird. Evidence shows that President Lincoln was thinking about that too. On April 11th, 1865, just 3 days before he was shot and killed, Lincoln delivered what will be his last speech. Speaking from a White House window to a crowd gathered below, the president shared some of his thoughts on what a post-Civil War America would look like. The speech offered a glimpse of how Reconstruction might have proceeded under Lincoln had he lived. One of the more important parts of his final speech was Lincoln's support of limited suffrage for African Americans. He advocated giving the vote to those who were, quote, very intelligent, unquote, or who had fought for the Union Army. Unfortunately, he'd never have the chance to put that plan into action. Instead, Andrew Johnson, the Southern Democrat, would become president, and under his plan of Reconstruction, instead we get black codes and the pardoning of former high-ranking Confederate officials, but no citizenship and no voting for freedmen. The next big change came in 1868 with the ratification of the 14th Amendment. The 14th Amendment does some pretty important things. First of all, it defines what is a citizen of the United States, anyone who is born or naturalized into the United States, and subject to the jurisdiction thereof. That eliminates diplomats who are not subject to the laws of the United States. And at this point, the naturalization process was mainly just maintaining residency in the United States for a particular length of time. Then, still in the first section of the amendment, the federal government guarantees to protect the rights of citizens against anyone attempting to deny those rights to citizens, including if the ones trying to deny those rights to citizens are the individual states. There's still going to be debate after this as to whether the right to vote is inherent in citizenship. I think a lot of that at the time of the 14th Amendment circles around whether women who were considered citizens and children who were considered citizens are not allowed to vote. Still, the 14th Amendment does later address the right to vote for the nearly 4 million formerly enslaved people who are newly minted citizens of the United States. It does so in Section 2. In Section 2, it states that representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. This is a clear repeal of the 3/5 compromise. It says basically, paraphrasing here, that we are counting everyone this time. There's no distinction in there between free peoples and all others. It's everyone is counted as a whole person. The rest of this section provides Southern states with an option to deny black men over the age of 21 the right to vote, but with a penalty. If black men were not allowed to vote, they wouldn't be included in the population count when apportioning representation to that state. So you can't, you can deny their right to vote as a citizen, but you then don't get to count them for your state's representation. This implied that men aged 21 and over who were citizens and residents of the United States do have the inherent right to vote. Of course, the 14th Amendment does not stop groups like the Ku Klux Klan and other white supremacists from using intimidation, threats, and violence to keep black men from the polls in the South. The voter suppression is so obvious in the election of 1868, the first presidential election that black men were allowed to vote, that Congress decided that they needed to act. So Congress will pass the 15th Amendment to the Constitution, which stated that the right to vote could not be denied to anyone on the basis of race, color, or previous condition of servitude. However, by being so specific, what ends up happening is they create a bunch of loopholes. Okay, you can't use those three specific criteria to discriminate against people on the basis of. So what else is there? Basically everything else. We will get to that more in a minute. Both houses are going to pass it by the required supermajority. It will go out to the states for ratification. And in order to ensure that that happens, Congress will make it a condition to readmittance that the 15th Amendment must be ratified by those states before they are allowed back in the Union. And due to that, the 15th Amendment will be officially ratified by February 3rd, 1870. As the former Confederate states were readmitted to the Union one by one, the Southern white conservative Democrats, aided by the KKK, began to take control of the state and local governments. The KKK and other paramilitary organizations worked to keep African Americans from voting, using the aforementioned intimidation, threats, and violence. They then appealed to Southern white Republicans by promising to lower taxes and limit the government. Of course, the biggest promise was a return to white supremacy in the South. Southern Democrats referred to this process as redemption, and the Southern white conservative Democrats as the redeemers. Once they gained control, they began to enact legislation to disenfranchise black men via legal means. Before we get into the details of how disenfranchisement was done, why is it such a big deal? I mean, more than 50% of the eligible voters in Texas just don't vote, and no one is ever really marching and complaining too much about that. So why was this such a big deal? Once the Southerners made it so black people in the South couldn't vote, that's going to open the door for the white conservative Southern Democrats to begin passing laws to keep black people in an inferior position in society, which started pretty much as soon as they could be sure that the president or Congress would not send troops in to enforce voting. In addition, juries are chosen from a pool of registered voters. If you are not allowed to register to vote, you cannot serve on a jury. Why is that important? I know most of us think that serving on a jury is, more of a time suck and not, a fun job. But it is important because when you remove black people from the pool of registered voters, that means that the juries in those states, in those counties, in those municipalities will tend to be all white, and that is going to make justice more difficult to achieve. That is why our right to vote is precious. So let's look at some of the loopholes used to deprive black citizens of their constitutional right to vote. First up, there's the literacy test. Remember that teaching slaves to read and write was generally a crime. So when slavery ended, the freedmen mostly could not read or write. So an easy way to exclude them without specifically referring to their race, color, or previous condition of servitude was to require a literacy test. And some people, people who are good, decent people who take things at face value. I believe that there are still those people like that who don't see ulterior motives. You could probably convince them that it makes sense that it is not completely unreasonable to test the literacy of someone before that they are allowed to vote, because shouldn't you be able to read your ballot before you're allowed to cast one? But the problem here is that it's never really about literacy. Instead, it's about making people jump through an additional hoop, and that way you get to gatekeep who is allowed to register to vote. And you can certainly tell that that is the case, that it isn't about literacy, because there's no effort included in these laws that would help a poor illiterate person who wanted to vote but couldn't read learn how to read. It would have been really easy to add that. And most of the literacy tests were entirely subjective. In Mississippi, for example, prospective voters were asked to write a reasonable interpretation of a section of the Mississippi State Constitution. But what is reasonable? It is basically whatever the white official who administered the test said it was. So it was pretty easy to fail whomever they wanted to fail. They actually tested this by sending a black lawyer trained to interpret the Constitution in to take the test, and still he failed. So it isn't about literacy, it's about denying people the right to vote. Next up was the poll tax. And again, if you are a I don't want to say hopelessly naive, but it seems like that person who sees things at face value, and someone tells you we should have a poll tax because elections are expensive. And you know what? Elections are expensive, but it's not about that. Estimates say that the 2020 election cost more than $2 billion to conduct nationwide, and that ends up being somewhere between $8 and $10 per person who cast a vote. So does it seem ridiculous that they should chip in $1 or $2 to offset that cost? No, but it's never really about that. Instead, it's about, again, making it difficult for people that you don't want to vote to be able to vote. And the poll taxes were never, really high. It was just made difficult to pay. And they do this by scheduling the payment due date in the end of January, which is a traditionally lean time for most people in the agricultural business, which is most people in the South. Also, they would require that the person who paid the poll tax keep track of the receipt for months until the election was actually happening. And that was difficult to do, particularly in the kind of environment that they generally lived in. Then, as if that wasn't enough, they made them cumulative, so that if you had a particular bad year and needed to skip a year, you still had to pay that year's tax to vote the next year. Finally, if that didn't work well enough, if poll taxes didn't work well enough to eliminate everyone that they wanted to, you're going to get something called the grandfather clause. These were clauses added to state constitutions that stated anyone whose grandfather was entitled to vote on January 1st, 1866, would then be entitled to vote regardless of tax or literacy. And that seems like maybe a random date, but it wasn't. It was chosen because it was before the 14th Amendment, or the Voting Rights Act of 1866 granted citizenship to the former enslaved people, which meant that no Black people would have been allowed to vote before that date. So without calling out specifically race, color, or previous condition of servitude, all Black people were eliminated from being able to vote. Then you have in southern states something called white primaries. White primaries were held by the Democratic Party because the southern states, the former Confederate states, voted solidly pretty much for the Democratic Party from 1880 to about 1952, with the exception of 1928. So the Democratic primary was really the one that mattered, not the general election, because whoever won in the Democratic primary was almost guaranteed to win in the general election. So voting in that primary was more important when it came to choosing who was going to represent you. And the Democratic Party in those states simply mandated that no black person could vote in their primary. And since political parties were allowed to set the rules for their primaries, this was seen as not violating the 15th Amendment. The Democratic Party claimed that they were a private organization and therefore could decide for themselves who they would allow to join. And they're going to use that as a way to stop people from black people from voting in the primary until a court case, Smith v. Allwright out of Texas, will overturn it in, I think it's 1944. Economic coercion is another way to stop people from voting that you don't want to vote. In a system where wealthy white primary holders are often the employers for poor, non-property black people, economic threat is a very effective method of control. Best example of this was Fannie Lou Hamer, a Mississippi sharecropper and fairly famous civil rights activist. She went to the county seat in Sunflower County, Mississippi, to attempt to register to vote. And when she came back home that night, her landlord came to visit, telling her that she needed to return to that county seat the next day and rescind her registration, or she and her husband would be evicted from their home. Hamer refused to back down. She said, "I didn't register to vote for you. I registered to vote for me." And because of her refusal to back down, she and her husband, Pap Hamer, lost their home and their jobs. But plenty of other people in the same situation, I'm sure, gave in. So economic coercion was used often. And when all else failed, intimidation and violence were used to stop black people from voting. After returning home from World War II, Medgar Evers, again, a famous civil rights activist, decided that he would vote in a Mississippi election. But when he and some other black ex-servicemen attempted to vote, a white mob stopped them. Edgar's related later, all we wanted to be was ordinary citizens. We fought during the war for America, Mississippi included. Now, after the Germans and Japanese hadn't killed us, it looked as though white Mississippians would. Unquote. So violence and intimidation were used quite often. I don't think that we'll probably ever know how many votes weren't cast due to violence and intimidation. By 1960, population increase in our nation's capital had grown substantially, and fully 54% of that population were black people. And as citizens of the District of Columbia, they weren't even allowed to vote in the presidential elections because they had no electors in the Electoral College. That is disfranchisement of a significant population. And it seems weird in a democracy that that type of thing could happen. So we will get then in 1960 the 23rd Amendment, which will extend the right to participate in presidential elections to citizens of the District of Columbia. The amendment grants the district electors in the Electoral College as though it were a state, but it limits it, saying that it can never have more electors than the least populous state, even though there are more people living in the District of Columbia than in the least populous state. So the 23rd Amendment was proposed by Congress on June 16th, 1960, and it was ratified and became the 23rd Amendment in March 1961. So that's one small group of people who were allowed a voice. Unfortunately, that is not going to be the case in Mississippi. Things were bad in Mississippi. In fact, it's the worst state in terms of race relations. Normally, I ask people if they're from Mississippi before I say that, but it is. In terms of race relations, it is one of the worst states and continues to be. Black people in Mississippi had endured generations of widespread denial of their voting rights, and by 1962, only 6.7% of all eligible Black voters were actually registered to vote, the lowest in the country. When anyone would question this, Mississippi officials would say something along the lines of, well, I guess they just don't want to vote. But we know that's not true, because we just finished outlining all of the reasons, the actual reasons why Black people weren't being able to register to vote in Mississippi. But civil rights activists needed to prove it in the 1960s so that they could, force the hand of the government to do some things about it. And so, in an effort to scuttle that flimsy excuse, in 1963, SNCC, the Student Nonviolent Coordinating Committee, is going to organize a mock freedom vote designed to demonstrate the will of Black Mississippians to vote, if not impeded by terror and intimidation. This is a mock election. It doesn't have any validity in choosing any officials, any office holders, but it was put on by SNCC, and it was designed to mimic what an actual election would be like. And in this mock election, which I feel like I need to emphasize this more, in this mock election that did not count for anything, what happens is fully 80,000 Black people showed up to cast votes in this pretend election, which represents somewhere around 20 to 25% of the eligible Black voters in the state. And if 20 to 25% of eligible voters would show up for an election that they know doesn't count, imagine how many would show up were they allowed to actually register to vote. So this is going to provide the data that they wanted and needed in order to kind of force the administration's hand to try to do something about voting rights in the South. One of the things that the Kennedy administration is going to do, being sensitive to the criticisms of the administration's commitment to protecting the right to vote. Early in 1962, Attorney General Robert Kennedy is going to urge the president to press Congress to take action, and they're going to target the poll tax. The poll tax had been targeted or attempted to be targeted multiple times previously by legislation that could not make it past the filibuster in the Senate. So President Kennedy instead put his support in behind a proposed constitutional amendment that would prohibit states from conditioning the right to vote in federal elections on payment of a poll tax or any other type of tax. He considered the constitutional amendment was the best way to avoid a filibuster, as the claim that it was unconstitutional would be a ban on poll taxes was unconstitutional would be moot, because an amendment would make it part of the Constitution. So it is going to pass both houses of Congress in August 1962 and be sent to the states for ratification, where it will be ratified by January of 1964. Texas, just FYI, did ratify this amendment, but it ratified it in 2009, so a little late, but better late than never, I guess. All right, then there are some court cases that are going to have things to do with gerrymandering. There are three really big ones: Baker versus Carr in 1962, Reynolds v. Sims in 1964, and this one, Wesbury v. Sanders, in also 1964. And all of these have to do with the one person, one vote kind of category, and drawing legislative lines so that districts, legislative districts, and at the federal level and at the state level have around the same number of people in each one of the districts, so that one person's vote doesn't count for more than another person's vote. And all of these lawsuits, all of these court cases are going to go towards that. And eventually it will affect all of the drawing of maps for voting, except obviously for senator, because each state gets 2 and there's no districting for that. So one person, one vote is the law of the land. In the summer of 1964, you're going to get a coalition of SNCC, the Student Nonviolent Coordinating Committee, CORE, the Congress of Racial Equality, the NAACP, the National Association for the Advancement of Colored People, and the SCLC, the Southern Christian Leadership Council, organized a campaign known as Freedom Summer, with the goal to register as many black voters as possible in Mississippi. Again, targeting Mississippi because Mississippi had the lowest black voter registration percentage of any state in the United States. More than that, however, the campaign was trying to build up the grassroots movement in the state. It called out for volunteers, out-of-state volunteers, to participate in Freedom Summer, and about over 1,000 volunteers will come. Most of these are going to be young, college-aged, most of them from northern states. About 90% were white. And they volunteered for this in spite of the fact that it was actually potentially very dangerous work. The volunteers were vigorously trained in order to try to minimize the risk. They were all expected to call and check in with the leadership at the same time every night and urged to be conscious and obey the laws. even to the point of, doing a check of your car every day to make sure that all of the lights and signals were in working order, and making sure that you did not, exceed the speed limit by even 1 mile per hour, because being pulled over and arrested in some of the backwoods areas of Mississippi was often how someone got disappeared. In spite of all of this caution and preparation, the 10-week project is going to be subject to some pretty bad things. Over the 10-week project, you're going to get the homes of 30 black homes or businesses were bombed or burned. Most of these are going to be homes that had opened themselves up to allowing the Freedom Summer volunteers to stay with them. 37 black churches will be bombed or burned. Again, it's churches that were, had allowed the Freedom Summer volunteers to speak to them and to sometimes sleep in their fellowship halls. 1,062 workers were arrested. That is combined out-of-state volunteers and local folks. 80 workers were beaten. 4 were critically wounded, and at least 3 of the local Mississippi black activists were murdered for their civil rights work, and 3 Freedom Summer workers were murdered. So we are going to look at the 3 workers who were murdered. They are Andrew Goodman, Michael Schwerner, and James Chaney. These 3 gentlemen, Schwerner and Goodman, were from New York. Chaney was a core activist who was actually from Mississippi, but assigned to go with these 2 visitors. These guys were arrested on June 21st, 1964, by a deputy sheriff in Neshoba County, Cecil Price, who was also a member of the White Knights of the Ku Klux Klan. These guys had gotten up in the morning, and they had driven to the site of a church that they had spoken in just days prior, that had been burned to the ground, and they had returned to that site so that they could talk to the people and see the damage. And on their way home, they were pulled over for allegedly speeding, I believe, and all 3 of the men were taken into custody, and then they were released after dark and released into a waiting ambush of Klansmen who abducted and killed them. They disappeared. No one knew where they were, and as soon as the men had missed their check-in, the SNCC and the other Confederation workers began phoning the FBI asking for an investigation, but FBI agents refused, saying that it was a local matter. Finally, after some 36 hours, someone who knew somebody contacted Attorney General Robert F. Kennedy, who then ordered an investigation, and immediately FBI agents began swarming around Philadelphia, Mississippi, where Goodman, Schwerner, and Chaney had been arrested. For the next 7 weeks, FBI agents and sailors from a nearby naval air base will search for the bodies, wading into swamps, hacking through underbrush. FBI director, J. Edgar Hoover, came to Mississippi on July 10th to open the first FBI branch office there. Throughout the search, Mississippi newspapers and word of mouth perpetuated the common belief that the disappearance was a hoax designed to draw publicity to the Freedom Summer event. But the search did turn up the bodies of 8 other black men found in rivers and swamps. One of them was 14-year-old Herbert Orsby, who was found wearing a CORE t-shirt. 2 others, Henry Hezekiah D. and Charles Eddie Moore, had been expelled from Alcorn A&M for participating in civil rights protests. The other 5 men were never identified. On August 4th, 1964, the bodies of Cheney, Schwerner, and Goodman were found buried beneath an earthen dam. You may ask what was done about these, the death of these men, and the answer, unfortunately, is not much. Murder is a local issue. It is an issue that local authorities are supposed to adjudicate, but when the local authorities are involved in it, then nothing was done. Finally, in 1967, the United States government, the Justice Department, found an old 1870 law called the Force Act that was passed in 1870 to try to destroy the Ku Klux Klan, and they used this old 1870 law to charge 10 men for violating the civil rights of the 3 deceased men. At the end of the trial, 7 of these men, including Deputy Sheriff Cecil Price, will be convicted and 3 will be acquitted. Sheriff Price was sentenced to 6 years and served 4.5 years of his term. The publicity that these guys, the death of these men got, as this case was reported on TV and on newspaper front pages, is going to shock the nation and draw massive media attention to Freedom Summer and to the closed society of Mississippi. So it was, you try to remember these 3 guys every time there's an election. All right, so in 1964, the federal government is going to pass the Civil Rights Act of 1964, which is going to basically do away with legalized segregation. And once that is passed, the African American community will want something to be done about voting rights. They will appeal to LBJ, asking him to do more to protect voting rights, and LBJ will tell them that they would have to wait, because he had spent all the political capital that he had trying to get the Civil Rights Act passed. But if you've ever read Martin Luther King Jr.'s letter from a Birmingham jail, you know that that being told to wait for rights usually means no, and so they aren't going to be told to wait. So instead, civil rights activists laid their bodies on the line once again. In spring 1965, SNCC and the SCLC are planning a march from Selma, Alabama, where only 2% of eligible black voters were registered. And they intended to march I believe it's 40 miles down US Highway 80 from Selma to Montgomery, the capital, and 54 miles, I'm sorry, to draw attention to voter suppression in the state. They had applied for permits to march on the road. Those applications had been denied, so the marchers are going to stay off of the roads, and they will instead march on sidewalks and on the side of the roads. At least that was the plan. They are going to leave Selma on March 7th, 1865. The plan was an estimated 525 to 600 civil rights marchers are going to head east out of Selma on U.S. Highway 80. The march is led by John Lewis of SNCC and the Reverend Hosea Williams of SCLC. They are going to cross the Edmund Pettus Bridge, and the Edmund Pettus Bridge it's elevated a little bit. So when you're leaving the town of Selma, it rises up and goes over the Alabama River, and then it comes down on the other side. So when you're leaving the city, you can't see what's on the other side. So they gathered in church. They then started marching on the sidewalks towards the bridge, and on the other side of the bridge, waiting for them, were Mississippi state troopers. They were issued an order to disband at once, go back home, that they were part of an unlawful demonstration, and when the protesters stood silently, and then the troopers began marching towards them. They had gas masks on. They released a lot of tear gas. Some of them were on horseback, and they began shoving the demonstrators. They beat them with nightsticks. They fired tear gas. Mounted troopers charged the crowd on horseback. They chased them. All told, 17 marchers were hospitalized. 50 others were treated at the scene, and countless others were less severely wounded. And among the hospitalized was the leader on the right-hand side of the group, John Lewis, who received a concussion and a fractured skull on the bridge there. The televised images of this brutal attack are going to be presented on television. And when that happens, it is going to rally support for the voting rights, the civil rights movement's focus on voting rights. And part of the reason it was called Bloody Sunday. And I always tell my students, if you Google Bloody Sunday instead, what you're going to get is not this, but generally a thing that happened in the 1970s in Ireland, in Londonderry or Derry, Ireland. But this one was first, so it should be this one. So the beatings happened on a Sunday, and television was interrupted on that Sunday in order to bring scenes from Selma, and what makes it more poignant is that the program that was interrupted on ABC network was Sunday Night at the Movies, and Sunday Night at the Movies was a big event for people before the dawn of streaming services and even DVD players, or even before that VCRs, which I know most of you don't know what that is. But the only way really to see a movie at this point in time is you either saw it at the movie theater, or you waited and waited and waited and waited until they would show it. And we're talking 10, 15, 20 years later, when they would show it on television. But Sunday Night at the Movies on ABC would bring a relatively recent film and show it with limited commercial interruptions on right there on your television on Sunday night. After you put the kids to bed, after they've watched, the wonderful world of Disney, then adults hunkered down and watched a first-run movie. On this particular night, March 7th, 1965, the movie that was being shown was a movie called Judgment at Nuremberg. And Judgment at Nuremberg was about the trials of the Nazi war criminals associated with the Holocaust. And it starred Spencer Tracy as this judge that goes over into Germany. He'd never been before. He goes to Germany to preside over some of these war tribunals, and he's put up in the home of a German home, and he meets the German people, and he thinks they're just so lovely. And every time he meets one of the German people, they all say, that how could we have known? We had no idea what Hitler was doing, and all of these things. And then in the course of the movie, he found out that, one of the prosecutors showed footage of liberating one of the concentration camps, and it stunned Spencer Tracy's character so much because he believed that there was no way that you could have possibly not known about it unless you willfully did not want to know about it. And it changed kind of his perspective on how he felt about these German people. So that is the movie that is going to be interrupted to show these scenes from Selma, and the juxtaposition of images of the Holocaust with footage of Selma, and how those people had willfully just not found out what was going on in their own country, and this showing exactly what is going on in their country. It's going to move people, and people are going to call out for something to be done to protect the voting rights of Black people in the South. And about a week later, on March 15th, 1965, Lyndon Johnson will present a bill to a joint session of Congress. I don't know if the video will work, so I'm just I'll quote it, and I will do my best to not do my Lyndon Johnson imitation, which is a problem when I read someone else's speeches. But he presented a bill to a joint session of Congress, and the bill is going to become the Voting Rights Act of 1965. And Johnson's speech in front of Congress was considered to be a watershed moment for the civil rights movement, because what he does is he places Selma in the history of the American fight for freedom, and then he quotes a really famous and really emotional civil rights spiritual that marchers oftentimes sang, that is, "We shall overcome," and he uses that quote to really kind of drive home the need for this bill to be passed. So he presents it to Congress, he proposes it, and it will, like I said, eventually it will pass, and it will become the Voting Rights Act of 1965. So the Voting Rights Act of 1965 is basically Congress deciding to enforce the 15th Amendment. In Section 2, it prohibits states from imposing any voting qualification or prerequisite to voting or standard practice or procedure to deny or abridge the right of any citizen of the United States to vote on account of race or color. In Section 5, it establishes federal oversight of elections administrations, providing that states with a history of discriminatory voting practices, so-called cover jurisdictions, could not implement any change affecting voting without first obtaining the pre-approval of the Department of Justice. This is a process known as pre-clearance. The enforcement provisions applied to states and political subdivisions, mostly in the South, but not completely in the South. New York, California were also included. That had used some sort of device to limit voting and in which less than 50% of the population was registered to vote in 1964. The act was renewed and amended by Congress 4 different times, the most recent being a 25-year extension signed into law by President George W. Bush in 2006. This piece of legislation is very, very important and wildly successful. And the results of it are pretty much immediate. Nearly 250,000 Black voters are going to register in 1965 in covered jurisdictions where only 29.3% of eligible Black population had been registered before the Voting Rights Act had passed. That number will increase to 52.1% just 2 years later in 1967, and similar increases are going to be seen in the number of Black candidates elected to office between 1965 and 1985. African Americans will be elected to, let's see, as state legislators in the 11 former Confederate states. There will be, it goes from having 3 in 1965 to 1985. There are 176. Nationwide, the number of African Americans elected goes from less than 1,500 in 1970 to almost 5,000 by 1980, and by 2011, that number is over 10,000. Research shows that the act successfully and massively increased voter turnout and voter registration, particularly among Black people, but not just among Black people. A 2018 study in the journal Politics found that that Section 5 of the 1965 Voting Rights Act increased Black voter registration by 14 to 19%. But white registration was also increased by 10 to 13%, which suggests that some of the overall increase may have come from reactionary people who are, protesting. So it's a really important law. It is wildly successful. And it has, massive consequences for the right to vote in the United States. In 1971, we are going to get the 26th Amendment added to the Constitution, and the 26th Amendment will lower the voting age from 21 to 18, where it currently is. And it's mainly in response to the Vietnam War, and it's mainly due to activists chanting, old enough to die, old enough to vote, because people, aged 18 to 20 are going to Vietnam and sacrificing their life for the country, but yet they're not allowed to vote. So it very quickly passes. You don't see a whole lot of amendments that are ratified in such a short period of time. It goes out to the states from Congress in March 1971, and by July 71, it's already ratified. So that's an important thing. Wanted to get that in there, in a chronological order, but it kind of messes up the flow because the next thing we need to talk about is the gutting of the Civil Rights, or the Voting Rights Act of 1965 by the Supreme Court in a case called Shelby County versus Holder in 2013. It's a case out of Alabama that asks for sections 4B and 5 of the Voting Rights Act to be declared unconstitutional. 4B, Section 4B is the section that provides the basis for determining whether a state needed to get preclearance. So it provides the criteria. If your state had this, then you need to get preclearance. And then 5 explains what preclearance is. And the court, in a 5-4 decision, is going to strike down Section 4B and 5 as unconstitutional. Chief Justice John Roberts is going to write the majority opinion, and said that it relied on 40-year-old facts having no logical relationship to the present day, and thus is not responsive to current needs. According to the court, regardless of how to look at the record, no one can fairly say that it shows anything approaching the pervasive, flagrant, widespread, and rampant discrimination that faced Congress in 1965, and that clearly distinguished the covered jurisdictions from the rest of the nation. So, in effect, he's saying that you can't say these people, these jurisdictions that need to have preclearance according to the Voting Rights Act, you can't say that they're racist because they're not racist anymore. But of course, the reason that they're not using racist laws anymore is largely because of the Voting Rights Act. The late Justice Ruth Bader Ginsburg wrote a scathing dissent that included the memorable line that throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. The ruling is going to completely gut the Voting Rights Act, and it will open the door for a slew of new voter suppression laws. Awesome. So some of these laws, since 2013, have been passed trying to make things more difficult, and they disproportionately affect minorities. There are some of the main categories of the way that voting is suppressed in the 21st century. First up is restricting voter registration. Restrictions can include requiring documents to prove citizenship or identification, like a passport or birth certificate, that are not carried by the average citizen. Onerous obstacles for voter registration drives. In Texas, for example, you have to be certified in every county that you try to register voters, which makes voter registration drives harder. There's limits on the window of time in which voters can register. In Texas, a citizen must be registered 30 days before the date of the election. Oftentimes, these laws are put into place in response to false reports of non-citizen voting. There are voter roll purges, cleaning up the voter rolls because people move, die, or become ineligible to vote for other reasons. But sometimes states use this process as a method of mass disenfranchisement, purging eligible voters from rolls for illegitimate reasons or based on inaccurate data, and often without adequate notice to the voters. A single purge can stop up to hundreds of thousands of people from voting. Oftentimes, people don't learn that they have been purged from the voting rolls until they show up at the polls on election day, and then it's too late to correct the error. So voter roll purges have been surgically used to deny people the right to vote. Voter ID laws. 36 states have identification requirements at the polls. 7 states, including Texas, have strict photo ID laws under which voters must present one of a limited set of forms of government issued photo ID in order to cast a regular ballot, no exceptions. And there, it's shown that over 21 million United States citizens do not have the qualifying government issue photo identification. And these individuals are disproportionately voters of color, because ID cards aren't always accessible for everyone. The ID itself can be costly, and even when the IDs are free, applicants must incur other expenses to obtain the documents needed to get an ID. This can be a significant burden on people in lower income communities. Further, the travel required to obtain an ID is an obstacle for people with disabilities, the elderly, and people living in rural areas. Again, voter ID, I put this in a category with the poll tax and with the literacy tests, where you can look at it on the face of it and say, this doesn't seem unreasonable, but there are ways to make it so it doesn't disproportionately affect minority people, and those ways are never included in the voter ID laws. It ends up being a disenfranchisement method. Then there's felony disenfranchisement. A single felony conviction can include the loss of your right to vote. In some states, ban voting only during incarceration. Others, or while on probation or parole. In other states and jurisdictions, it's permanent. And the fact that these vary from state to state adds to the overall confusion that voters face, which is a form of voter suppression in itself. Plus the draconian punishments that are levied for people who mistakenly try to vote when their particular state has a slightly different rule, and then they are punished to the fullest extent of the law, including years in prison and another felony conviction, by the way. That also will keep people from even trying to go forward and vote. So that is something that is affecting a lot of people. And then there's gerrymandering, and every 10 years states are to redraw district lines based on population data that is gathered from the census that happens every 10 years. They are supposed to draw district lines to allocate representation in Congress and state legislatures, and too often redistricting is a political tool to manipulate the outcome of elections. I believe it's like choosing your it's office holders choosing their voters instead of voters choosing who holds office, and it stifles the voices of millions of voters. So these are a few of the more recent ones. There are even more recent ones after this that have come up recently. If we're coming to fully current events, there's another case that will further neuter the Voting Rights Act of 1965, and that's Brnovich versus the Democratic National Committee, a case out of Arizona dealing with two policies in violation of Section 2 of the Voting Rights Act, one outlawing ballot collection and another banning out-of-precinct voting. The Supreme Court is going to issue a 6-3 decision that states, again, I am this isn't an exact wording, but it's basically that just because the effect of the law burdens minority population doesn't mean that the laws are racially biased themselves, which weakens the Voting Rights Act by limiting the kind of burdens that can be brought to court. The Voting Rights Act of 1965, wildly successful and now being torn down bit by bit. In recent days, we have had two different pieces of legislation to correct some of these issues. First of all, HR 1, the For the People Act of 2021, was proposed and passed by the House of Representatives, but stalled in the Senate when it failed to garner the 60 votes required to overcome the filibuster. If passed, it would do things like require same-day voter registration for federal elections and permit voters to make changes to the registrations at the polls. It would require at least 2 weeks of early voting, including weekends. Establish an automatic voter registration as soon as someone turns 18. Establish, I think we have motor voter now, where if you go and have your license, your driver's license, they have to ask you, do you want to register to vote? The For the People Act would take away that question, and it would automatically register you to vote unless you said, hey, don't register me to vote. It would establish Election Day as a federal holiday. It would expand vote by mail opportunities. It would require online registration, restore voting rights to felons, ban voting roll purges within 6 months of the election, require a paper ballot trail, and it calls for campaign finance reform, require president and vice president candidates to disclose 10 years of income tax returns, and require states to use independent commissions to draw congressional maps. All of this and more. Seriously, there's more in this For the People Act. It was like too much for me to write down. And then the other one that failed was the John Lewis Voting Rights Advancement Act of 2021, also known as HR 4, was proposed legislation to restore and strengthen portions of the Voting Rights Act of 1965, particularly those that have been gutted by the Supreme Court. It again passed through the House of Representatives, but stalled in the Senate twice so far by failing to garner the 60 votes required to overcome a filibuster. If passed, this would update Section 2 that had been weakened by Brnovich versus Democratic National Committee, broadens the scope of the courts, so this would expand the violations for which the U.S. Attorney General could send in federal observers and the courts could block from being enforced. It would restore federal preclearance, and it would expand the covered practices, widen the type of changes that are subject to preclearance, including changes from single-member districts to at-large districts, redistricting maps, voter ID requirements, multilingual voting materials, voting locations and opportunities, and voter roll maintenance. These things were packaged together, and they were named after John Lewis because John Lewis unfortunately passed away in 2020, it was to honor him, but it didn't make it through the Senate due to the filibuster. So that is where we are, and I welcome your questions. I'll leave you with this quote. I know this quote, and then when I tried to find who had said it, all I could find is Common, and I don't think it was actually Common who said it first, but it's basically, if your vote wasn't so important, why are so many people working so hard to keep you from voting? And I would just like to state that democracy is scary to a lot of people, and make sure you vote. March 1st actually is a primary here in Texas. Early voting is currently going on, so if you're registered to vote, I encourage you to go out there and cast your vote. That's I yield to questions then, if anybody has anything.
All right, thank you, Karen. It was a very good presentation. We do have one question from a student,
Okay.
and the question is the people who created the test, talking about the literacy test,
Mm-hmm.
and they also failed their own literacy test. He may have misunderstood something that you'd said there.
Mm.
So the question is that did the people who created the test also fail their own literacy test?
Um, no, I would say no. The people who created the test, by definition, could not fail their own test because they're going to be the ones that determine who fails. And it really was as simple as that. The person who is generally the person who is administering the test has already determined whether you're going to fail or not, regardless of what your answers are. I think it's kind of like, there are professors who won't give 100 on on things because if I look, I can find something, and
Gotcha.
and usually the tests are so narrow that or so nebulous, I should say, that if you miss one out of 30 questions, which is still like a 96% in reality, you fail if you miss one question. So all they have to do is find something to fail you on, and they can and will. So it's I think maybe what we were talking about was the Mississippi one where you were supposed to it would give you a piece of the Mississippi or the U.S. Constitution and say, can adequately explain what this means. And they actually, the NAACP and other civil rights organizations would have lawyers, people who are trained in the law and interpreting the Constitution and so forth, go in and try to take these tests, and they would fail because the person administering the test is the one that determines whether it is adequately explained or not. And because it is such a subjective term, adequately, you don't really have to work very hard to eliminate people.
Yeah, I thought you did a really good job with that example. Bringing in a lawyer who obviously knew what he was talking about, but it was, as you say, subjective. So I wonder if you could just take a moment to explain the role of the filibuster. I know you kept coming back to how the filibuster was a problem in getting modern legislation passed. Could you just take a moment to kind of explain what the filibuster does or why it is a problem?
Yeah, the filibuster is it's in the Senate. It is a Senate procedure, and what they've done is it's a thing calling invoking cloture. Try not to use that too much because people get all glassy-eyed when you talk about Latin terms and things like that. But invoking cloture means we're going to call an end to the debate on this bill. The Senate has unlimited debate on things. If you can pass it, something, it can be debated forever until you invoke cloture. And you need 60 votes in order to end debate on an issue, on a bill, and bring it up then for an actual up or down vote on whether it passes. 60 votes is nigh impossible to get on voting rights now. Interestingly, in 2006, it wasn't hard. In 2006, when they re-upped the Voting Rights Act of 1965 for 25 years, I believe the vote was something like 98-2, and it in the interim, in the 15-16 years interim, things have changed. Partisanship has grown, more tribal and so forth, and people are more firmly entrenched in their things. And getting 60 votes to end debate on it and send it to an actual vote where it will pass or fail by a simple majority is almost impossible to do on some of these more I don't want to say controversial subjects because I don't know why voting is, but it seems to be extremely controversial. Yeah. If that, I don't know if that was a good explanation or not, but
No, that was perfect. Yeah.
okay.
Good job.
Yeah, it used to be that you would have a talking filibuster and then people would get up there and, like read recipes and things like that because they have to actually stand there and talk in order to stop people from voting to end debate. But now the procedure has changed so much that all it takes is just one senator to say, I'm going to filibuster, and it's like, that's all it takes, I guess. Then you absolutely need the 60 votes to stop it. And like I said, it's very hard to get.
Well, going forward, what do you think the future of voting rights looks like in America? I know that's a speculative thing, but based on what we've seen in the past and now the modern times, do you think we'll get the Voting Rights Act passed anytime soon?
That's well, one of two things have to happen for it to pass, and that is there either needs to be 60 votes in the Senate, or the other potential possibility is to have a simple majority of the majority in the Senate, just a simple majority, to vote to, do away with the filibuster. And that seems like a more plausible answer than the 60 vote threshold, because they tried to do that. They tried to overturn the filibuster or carve out an exception to the filibuster for voting rights, and it was denied by two senators. So there are two senators. The Democratic Party is two senators away from getting voting rights passed. So 2020 is an election. 2022 is an election year. So if they gain two seats in the Senate, and they maintain control of the House, then maybe it could be passed. But those are big ifs because it is not looking real good right now. I don't know. It changes daily. The the forecast as to who's going to control the House and who's going to control the Senate. I suppose we'll know sometime in November. But yeah, if they do away with the filibuster, it could get passed. But that's about the only way that could happen right now. So in the meantime, I think it's incumbent on all of us to vote. And voting is like I said, it's a very important right, because it is the one out of which all of the other rights come. And so if we are to maintain our representative democracy, it's incumbent on everyone to vote. And for whomever you wish to vote for, just get out there and make your voice heard, because it is your voice in your government. So
all right, well, thank you, Karen. We don't have any other questions, and you did a really good job of explaining everything going all the way back to the beginning of the Republic. So thank you for your presentation. I hope everyone enjoyed this. And yeah, that's it. Thank you for your time.
Okay. All right.
Bye, everyone.
Thank you. All right.